Oh, good.
Get started
My
on this
apologies.
end.
You
No
bet.
problem. I will let you know once we're good.
Okay.
My apologies.
My apologies. You bet.
Okay, Mr. Chavez, we are good to go. Thank you.
Oh, good. Thank you again, Mr. Moya. Okay, so today's date is February 10th, 2022. My name is Stephen Chavez. I am the liquor hearing officer for the city of Albuquerque, and this matter was delegated to me by the city council to make a recommendation on pursuant to the IDO. I understand that there are quite a few people involved in these appeals. And by the way, these appeals are consolidated, and the numbers are AC-15-21 and AC-15-16. I've consolidated them because they essentially involve the same legal issues under the IDO, the same appeal issues, and the same decision from the zoning hearing examiner. The difference in the appeals is essentially that technically one concerns one piece of property, the other concerns another piece of property at the same site. I didn't see any evidence in the record that would give me the opportunity to separate the appeals, so I've consolidated them. Mr. Wells, you are here.
Yes, sir. I'm here and ready.
Good morning. And it looks like Mr. Kalitsis. Am I pronouncing your name correctly, sir?
Yes, you are.
Okay. Good morning. You are the appellant, and are there other appellants? I did note that in the form, the appellate form that you filled out with the city, it was just your name only. But in the write-up by the city planning department, they included two names. So if there are two people, that's fine. I'm not going to ding you for that on time. Are there two appellants?
There actually is the three neighborhood associations, Siesta Hills, Parkland Hills, and Elder Homestead. And I was submitting it for them as represented for them. And we, as three neighborhood associations, have put in this appeal.
I understand that, but I guess my question, and my apologies, my question was, are you representing all the appellants?
We are.
We are, and who is we?
Melinda Frame, Leslie, myself. We also have some presidents of the neighborhood associations here, and some of the people involved in case there's questions that need to be clarified.
Okay, so
Mr. Chavez, this is Chris, the court reporter. I was barely able to sign on just now. I don't know if your meeting has started already, or you're doing preliminary matters.
it has started in preliminary matters.
Okay.
Thank you, Mr. Sanchez, for letting me know. What I suggest you do is go to the Zoom record. You can obtain that from Mr. Moya to get the preliminary matters, and we will start from that point on with you. But I think that you need to include what we've already done in the in your official transcript. Can you do that through the Zoom process?
I'll ask Matthew.
Okay, Matt with the court reporting
Correct.
company that you're with, right?
Correct.
Okay.
So
Yeah,
you've been on the record for 5 minutes then, right?
We've been on the record for 4 minutes.
Okay.
Okay, and we're essentially making introductions.
Okay, that's fine.
Okay, thank you, Mr. Sanchez.
I'm ready to start writing.
Excellent, great. So I was going to say, sir, Mr. Kalitsis, did I pronounce your name correct, by the way?
Sir.
Okay, you've never been involved in these appellate processes that I've been aware of. I've been doing this a very long time and I haven't seen you before. So let me remind you that I do stick to the IDO. The issues under the IDO for this appeal do not allow me to reopen the record, to allow new evidence to come in unless I determine that it's necessary for a fair disposition of this matter. I think the record is pretty well made. I've reviewed the entire record. That is, I've read the entire record. It's a very short record, lots of duplications in the record. So I am familiar with the record. I won't allow you to bring people in to testify regarding this appeal. Certainly, you and your cohorts can make arguments. I will allow that, but But as far as evidence goes, I'm not going to allow any more new testimony in this appeal because this is a closed record appeal. Excuse me. I have a sore throat this morning. This is a closed record appeal, and I'm only required to make recommendations on the record, okay? And so this is not like we're doing it all over again in front of the ZHE. Do you understand that, sir?
Yes, I do have a question.
Go ahead.
I thought new relevant evidence that wasn't available could be, you could make a decision whether to examine it to determine whether it could be included.
That is correct, if it wasn't available at the time of the ZHE hearing. So which leads me to the next issue. We have some preliminary matters regarding evidence and arguments that were supplemented in the record. I don't have a problem with what was provided so far by you in supplemental evidence. Your package, I think you emailed it a few days ago, and Mr. Wells sent me an argument, pure argument. It's not new evidence. I will accept those into the record. Your supplemental packaging was riddled with technically new evidence because you provided articles and transcript portions from discussions. I don't particularly find that relevant, but I will include it in the record unless Mr. Wells has an objection. Mr. Wells?
Mr. Hearing Officer, the city chooses not to take a position on this.
Okay. Well, I will allow it in the record, but there is one piece of evidence I will not allow in the record. And I received an email from the Chamber of Commerce, and they wrote a long detailed letter. I cannot include that into this record because it wasn't included into this. Let me put it this way. There was a letter from the Chamber of Commerce that was included in front of the ZHE. This is a new letter. I won't include the new letter because it should have been included into the ZHE's record. And it's essentially not necessary for me to dispose of this matter for the city council. So I will not allow that letter to come in. The city council will have the ability to overrule me. Obviously, they can review all that evidence and determine for themselves if they want to allow it to go into the record. They will have that ability. It will be included into the record. It'll be offset with the recommendation for me to not include that letter into the record. Having said that, any more questions between the appellant and the party opponent?
No, sir.
Okay, let's get started. Mr. Kalitzis, I need to swear you in. Excuse me.
All of it's in right.
Please raise your right, Ms. Frame. And who else is there?
Leslie Padilla.
Ms. Padilla, thank you.
Leslie Padilla.
I can see you. Okay, do you folks swear to tell the truth, only the truth, under penalty of perjury?
We do.
Yes, I do.
I do.
Thank you so much. Okay, let's get started. I'm going to be flexible with time. But if I do believe that you're getting repetitive or getting into areas that I think are not in the record, I'm going to remind you to stay on track, or I will just tell you to stop. Okay?
Yes, sir.
Thank you so much. Go ahead.
Okay, I'm just going to read from what I have here so I can stick to time. But
Ms.
I am
Frame, Ms. Frame, let me stop. For the record, your full name?
Melinda Frame.
Okay, thank you.
So yeah, my name is Melinda Frame. I'm here to speak on behalf of Parkland Hills, Elder Homestead, and Siesta Hills neighborhood associations, whose neighborhood reps are also here as panelists. We'd like to state that we understand the need to help the unhoused of our city, and we support the ideals behind the Gateway Center. Our concerns lay in the city's failure to meet its own rules and procedures, both within the IDO and City Council Bill R-21-141. Beyond the intricacies of the IDO violations we cite in our slide presentation, with proposed stays of up to 90 days, at its most basic level, the Gateway Center does not comply with the IDO's definition of an overnight shelter, and after further research falls more in line with a large group home. Furthermore, their application also fails to address more substantive issues of equity, sustainability, and adverse impacts. Our goal in making this appeal is to hold the city accountable and to make the Gateway Center and our communities sustainable and safe, which will benefit both the residents and businesses of our neighborhoods and the residents of Gateway. With the aim of sustainability and public safety at the core of our appeal, we propose conditions be attached to the approval of this permit. And so the center aligns with the vision for sustainable neighborhoods in the ABC Comprehensive Plan, while also ensuring the city honors its commitments to the community. During the zoning hearing, hard evidence was ignored, and the zoning hearing examiner was dismissive in his findings.
What evidence was ignored? You need to be very specific, because in order for me to help you,
Sure.
you need to specifically tell me in the record what he ignored, because general arguments don't work with me.
Sure. So one of the things, like, we provided studies for him as far as adverse impacts. We provided different articles from Santa Fe, New Mexican, from the Journal, from a publication in Arizona regarding impacts of nearby shelters on the surrounding neighborhoods. He stated that those weren't relevant because he cited, like, Pete's Place in Santa Fe being a temporary shelter, that it was not permanent. Though, you know, as far as how long it will be in operation is indefinite at this point. It's not a set period of time. It's not like a winter shelter or just a COVID relief shelter, et cetera. And then Leslie.
Are you sharing your screen?
Hold on.
Sorry. Oh.
Ms. Padilla,
Yeah, I just wanted to make one.
hold on. I understand, but let's be very careful with the record, because Mr. Sanchez will chastise me. He will admonish me for not being able to take more than one person at a time into the record. So let's do that. Let's just
Mr.
one
Hearing
person at a time.
Officer, sure. Mr. Hearing Officer, this is Leslie Padilla. I just wanted to remind Ms. Frame that she does have, we do have a presentation of the full oral argument to share. And actually, it will address your question, Mr. Hearing Officer. There is evidence that Ms. Frame will point to in her prepared oral argument.
Okay. It's up to Ms. Frame if she wants to allow people to see that. You're referring to what you supplemented the record with, correct?
Correct.
If you want to share your screen, I think Mr. Moya knows how to do that. I don't know how to do that.
Okay. Yeah, I would like to share the screen. That would be great. Okay.
Mr. Moya?
Yeah, Mr. Chavez. Yep, there it goes.
Thank you so much.
No problem.
I can see it myself.
Okay, good.
Mr. Wells, can you see it?
Yes, I can. Thank you.
Good. Okay, go ahead.
Okay, so that was one of the things that he dismissed, but there we have a whole body of things that we have in our slide presentation that we did submit that we will address in our oral argument, the things that were overlooked or not addressed in his findings, or where his findings were inaccurate as far as distinguishing things like between the IDO and the city council bill, et cetera. There's a number of them, and we have them out. This is just my introduction. We are going to go specifically outline them within the presentation.
Okay.
Okay, should I go forward?
It was totally up to you how you want to use the time.
Okay. So let me find my place here. So yes, the fact is the city has not met its burden of proof, and the ZHE flipped the burden from the applicant onto us. Relying on the city's good intent in its operations plan is not meeting the requirement. Because of this, the decision was arbitrary and capricious, and the city's application does not meet the requirements of the IDO and the comprehensive plan. Today, we ask that you address the evidence with the thoughtful consideration it deserves so it is not overlooked again. We submitted our appeal items number 1 through 8 on page 42 through 43 of your packet in reference to the order of the ZHE findings. But in our oral presentation, we will be presenting our arguments in relation to contextual content. We will begin with item 1 from our appeal regarding the applicant's failure to meet the requirements of City Council Bill number R-21-141. Without meeting the requirements of Section 1 of this bill, Section 2 mandates that a conditional use permit not be issued. Section 1 states that the city shall establish a good neighbor program for the Gateway Center that offers at least 2 community input sessions for neighbors, neighborhood associations, and businesses located within communities adjoining the Gateway Center, and kicks off or advances discussions towards a good neighbor agreement by the city with area residents and businesses. So regarding the ZHE's finding number 10, stating that 2 meetings were held, we're not arguing this. Yes, the applicant held 2 input meetings, and yes, they did notify neighborhood associations. Where they failed to meet the terms of the bill was in their failure to invite and engage businesses in these meetings and bring them to the table in the development of the Good Neighbor program. During the ZHE hearing, the applicant's agent tried to pawn off this responsibility to the neighborhood associations. but this was the responsibility of the applicant. And the ZHE overlooks this requirement of the bill entirely. So the businesses were completely disregarded, first by the city, then by the ZHE. In regard to finding number 11, where the ZHE states that all property owners and neighborhood associations were notified.
But
Yes.
Ms. Frame, may I interrupt you and ask you a
Sure.
question?
Of course.
Okay, so with regard to finding 10, your position is that the two sessions you believe were met, but you believe that the businesses, the business owners were not included into the good faith process that was set up by the resolution. Can you please clarify that for me
Sure.
a bit more? You
Sure.
speak pretty fast and it's hard for me
Oh,
to
I'm
understand
sorry.
what you're saying.
My apologies, I'll speak slower. We believe that they were met in terms of inviting the neighborhood associations. They were not met because they did not invite the businesses. We asked on numerous occasions at different meetings with the city about how they were reaching out to businesses and contacting them. We were told on 2, if not 3 occasions that flyers were going to be mailed out to them. Flyers were never mailed out to them. They received no communication. And prior to the hearing, we did go on foot and just started, talking to businesses. We do have a petition that shows further in the presentation that none of them had received any communication from the city. And in his
I apologize, but I understand that's your argument, but I guess I don't understand how the ZHE erred, because you're saying, it seems to me that you're saying that the city is obligated to reach out to business owners pursuant to this resolution to bring them in. But what happens if a business owner doesn't want to participate? Let me finish my question. And what happens if they offer, let's say, in general correspondence, and there's no response from business owners nearby?
Well, I think then they at least have had the opportunity, because they were invited as per the bill requires, and that's their choice not to participate, but they need to be given the option of participating by being invited to the table.
What table is that? What the
For the
two
input,
sessions?
the 2 input sessions, correct. The bill also goes into more detail as far as, they need to be able to receive ongoing updates, information sharing and gathering, and a point of contact at the city for presenting their concerns is what the bill specifically requires. And they didn't receive any of that. And I know the IDO thing. Peter has something to add, sir.
Well, may I continue to ask questions
Sure,
regarding
of course.
that issue? Because I just need to understand it a little bit more. So it's your position that the 2 sessions were not just for neighborhood associations, but were for the residents as well as the business owners. I agree with you there, but isn't the outlet for, or the forum for the business owners and the residents to participate is through the neighborhood association?
No.
No?
The neighborhood association in the city's
And
resolution.
Mr. Kalitzis, so that I don't have to interrupt every time a new speaker speaks, please introduce yourself or Mr. Sanchez. Okay.
Peter Kalitzis. In the resolution, it calls out distinctly neighborhood associations and businesses separately. It identifies businesses. And the example of the fact that their lack of notification is the businesses, including ones that are directly across the street, who were not notified at all about this meeting.
What evidence do you have that supports that?
We have the petition that we submitted in the records.
I just put it on screen right now. The full petition, I wasn't able to fit all the signatures on this page for the purposes of the slideshow, but the full petition is within the evidence.
Now, when it says, and I read the petition, and my apologies, I just like to play devil's advocate so that I can narrow down the issues. It says minimal communication.
No
Well,
communication.
hold on, let me finish my question. So minimal communication, not zero communication. And you're arguing that they were never contacted. That's not what this petition says.
It is
Can I-
Peter Kalitzis.
Yeah,
Go
can
ahead.
I-
Oh,
This is Melinda Frame again. So we put that when we were, because we didn't know when we first went out to have this petition signed, if they'd had it or not. So we wrote minimal to no. But I mean, this is you taking me at my word, but when we did go and have it signed, none of these that appear on this list had any contact. But for the purposes when we went out, not knowing what we would encounter, that we just thought that was safe wording.
And we're speaking now regarding your argument of the 2 sessions, correct?
Correct.
Okay.
Yeah, solely for the city council bill at this point. And I think what happened when we look at the ZHE's finding number 11, when he states that all property owners and neighborhood associations were notified, he's speaking to the terms of the IDO. So he's dismissing the requirements of the city council bill in his finding regarding the notification and by referencing a required notice perimeter, because the city council bill does not outline a perimeter, but rather mandates including businesses in the broader communities adjoining the Gateway Center.
I take exception to that term broader, because it seems to me, and I read this resolution several times because it's a little inartful, but it gets the job done. It clearly states a purpose, and it clearly includes the criteria for who is to be included. And I thought that there was language that it used, such as property owners, businesses that are adjoining the proposed uses, adjoining the proposed uses and within the closest proximity to the closed uses. Those were the 2 terms I recall in the resolution. I don't remember a term for the broader community.
So can I just first, and it doesn't say property owners, it does say businesses versus property owners. So the IDO states property owners. This says businesses, which like along that whole strip mall, obviously that's across the street, there's one property owner of the strip mall that would be notified through the IDO, but then all the individual businesses in there, those are separate. So as the city council bill reads, our understanding is that it's the actual business owners inhabiting that space versus, the property owner of the whole strip mall, as per the IDO. Peter.
Peter Kalitzis. Per the IDO, the requirement would have been met per the IDO because it says property owners. Very clear, and it's within 100 feet plus the neighborhood associations. Per the resolution, I don't recall it using the term property owners, businesses, neighbors, and as I recall, community. So the language is considerably different. So we look at the ZHE's decision, it looked at it based upon the IDO. It did not address the resolution 141 as far as the requirements. We're trying to bring it up on our screen to see the exact wording. Okay.
Neighborhood associations and businesses located within communities
Melinda.
adjoining the Gateway Center.
So it's your position that the business owners adjoining the location, the Gateway Center, were not included into the 2 sessions?
Correct.
Okay. And you're saying that they did not receive notice of those 2 sessions?
Correct.
Okay.
Correct.
And the notice that you say they didn't receive was mailed notice or emailed notice, but specific notice?
Any notice? Yeah.
Well, I don't know if you've proven any notice. I didn't see in the record that the businesses didn't receive notice, but we can move on. You can show me, if you can point to the record, I'd appreciate it. But if you can't, it's okay.
As far as point to the record.
To the notices that were sent to the neighborhood associations that did not include the business owners.
Oh, I can.
Adjoining the Gateway Center.
I got
I'm only
you.
talking about those adjoining the Gateway Center, not the broader community.
Yeah, I would have to go, I can go into my email and try and pull that up. It might take me a little bit.
We can come back to it.
Okay, but I do have the email from our neighborhood association president that he forwarded to me that shows at least all the neighborhoods and people that were on that email notification.
Now, is that in the record? Because if it's not in the record,
Yes.
Okay.
It should be in the record. I'd have to see if within the record, if it has all the addresses of everyone, but that email courtesy notice that went out is in the record.
Okay. Let's move on for now.
Sure. So we might, let me just go through here and pick up where I was. So yeah, so we're just trying, we feel that in his findings, like in finding number 11, he's not distinguishing between the IDO and the city council bill. And this error is seen again in finding number 12, in which the ZHE states that the applicant timely mailed neighborhood meeting requests on June 4th. The June 4th meeting notification was for the pre-application meeting mandated by the IDO, not for the 2 input meetings mandated by the city council bill, for which no notification was sent to the businesses. So the ZHE is an error and is neglecting to recognize the different requirements for the city council bill, again, from the IDO requirements.
So let me get that straight. So finding number 12 is for the pre-application meeting?
Correct.
Or pre-submittal?
Yes, pre-submittal meeting. So he states that the applicant timely mailed neighborhood meeting requests on June 4th, which that was mailed on June 4th, but that was for the pre-submittal meeting. So
Okay.
he's kind of blurring the lines. I think he's getting confused, or he's not addressing them as 2 different sets of mandates.
Okay.
So with this, the city council bill's mandates were not met, and without meeting the requirements of section 1 of this bill, section 2 states that a conditional use permit not be issued. And as of September 15th, more than 6 months after the purchase of the property, at least 24 neighborhood businesses, many of them directly across the street from the property, had minimal to no communication from the applicant, and they did not receive notification by the city to the input meetings. So without, our point is that without notification, they were unable to participate. And I will go when we have a pause here and try and dig through my emails to find that courtesy notice where all the people that were notified are on it. And furthermore, they did not receive the ongoing updates, information sharing and gathering, or a point of contact at the city for presenting their concerns as mandated by the bill.
Okay. Now here's another question that maybe you can answer, or Mr. Kalitzis can answer. The resolution didn't actually require notice to anybody. It just required that the sessions include these folks. And again, my first question was regarding the duties of the neighborhood associations, because under the city ordinances, neighborhood associations have duties and obligations of their own. To become a recognized neighborhood association, I'm just recalling this from memory, so I'm paraphrasing, but it seems to me that there is an obligation in the city ordinances that a neighborhood association has to notify residents within their association, which may include business owners. So did the neighborhood associations meet those obligations for these 2 sessions? Did the neighborhood association notify the business owners within their association regarding these 2 sessions?
This gets a little bit complicated.
It sure does.
Because there is an additional neighborhood association, which is not a party to this, where some of the businesses are located. And to our knowledge, they did not communicate. I know Elder Homestead did communicate. They actually have a business member on their board to the extent that they could. We're talking communications being emailed out.
Yeah, I can only speak, I mean, I'm the homelessness solutions chair for our neighborhood association. And I'm working with the city. I'm on panels with the city for this project. So I know I myself emailed the businesses of our neighborhood, but I can't speak for the other neighborhood associations.
Okay, I'm just curious because there are those obligations that neighborhood associations have. And I don't know if it's just for recognized neighborhood associations or for all neighborhood associations, but I'll make that distinction later. The term offers is what's emphasized here. And Mr. Wells is going to tell me that the city substantially complied, because under New Mexico law, there are issues regarding what is substantial compliance. And so if these neighborhood associations or these business owners specifically, if they knew or had reason to know, had the ability to know about what's going on, it seems to me that the city has met their obligation under that term offers. But that's a broad analysis. I'll look at that, but I'm just not convinced entirely by your argument. I'm sorry, but I will look at that closer, and you have my promise on that. Okay.
Can I ask a question? Because I know there was a meeting back in May with the Homeless Coordinating Council where they actually addressed this, that they said on the record that they would be sending out flyers and getting in contact with the businesses. So to me, by them stating this back in May of 2021, it's showing they understand this to be their responsibility. So that, I guess that's where, when we're drafting this argument, we're going back to this because it had been told to us that, they were going to have, take that responsibility on themselves to get in contact with them.
Okay.
Peter
Kalitzis. My confusion here is we have a series of businesses, Siesta Hills Shopping Center, which is directly across the street. And the fact that we're talking these businesses across the street, what's going on, they're busy running their business during COVID and after COVID. And the fact that I just would, if they didn't see flyers, didn't get any emails, I don't see how the city would actually be considered getting communication out, but that's, we're talking directly across the street, it's.
I think there's the proposition that people have duties of their own. That is, there are duties that people have to fulfill as citizens, and they can be charged with knowledge of certain things that are widely and publicly known. Now, I may be taking a too expansive view of that. I don't know. I'll look at that closer. But let's move on a little bit to the next issue if we can. I know you have several issues.
Could I say just one thing? With the IDO, the owner of the property across the street had to receive notice under the IDO. Those same locations, it sounds like, did not have to receive notice under this, even though they were within the same proximity as the IDO, except because the IDO says landowners, if you own a business, you're not entitled to receive notice under the IDO.
I don't think that's true, because they have to meet the IDO provides notice to people within a certain proximity. And it doesn't matter if it's a resident or business owner. It's all the addresses, if I'm not mistaken. Maybe Mr. Wells or one of his witnesses can clarify this, but it's my understanding that the IDO requires notice within a proximity to all property owners, whether they be business or not. So anyway, let's move on, okay?
Yes.
Okay, so beyond these issues within the city council bill, in item 2 of our appeal, we addressed the applicant's failure to meet the requirements of the IDO. If we look, let's see. The applicant's first violation of IDO procedures relates to the meeting request mandated by the ordinance. And in the ZHE's finding number 12, he errs by stating that a timely neighborhood meeting request was sent because the adjoining neighborhood of Parkland Hills was not sent a meeting request, but rather was emailed a courtesy notice. So although they are legally required to receive notice as an adjoining neighborhood. And while this is a minor infraction, it shows the rushed and sloppy nature of the process. And
Ms. Frame, I'll let you make that argument, but I just don't buy it.
Okay.
Whether it's a courtesy or not, it's still notice. It
Okay.
doesn't matter how, if it's a courtesy is a polite gesture, correct? So whether it's a polite gesture or you've received notice, to me, it's just an irrelevant argument. But if you want to go ahead and spend your time making it, I'll give you some more time on that.
No, I mean, I think the main thing is that we just feel that our neighborhood as an adjoining neighborhood wasn't given the same treatment as South San Pedro or District 6 Coalition as an adjoining neighborhood. Jackie Fishman in her email to our neighborhood association president recognized this error. And going forward, we were included, but I think, under the ZHE's hearing where they stated they followed the IDO notification process and application requirements to the letter of the law is inaccurate. But more significant though, I mean, to your point, that was a minor infraction. More significant though, are their failures in meeting the terms of the IDO and addressing required information to the affected neighborhoods. And we'll start with at the pre-submittal meeting. If we look at IDO section 6-4C6, hold on, sorry, I've got myself lost here. Although proper protocol for this meeting, didn't go through as far as notification, as referenced in the ZHE's finding number 13, a pre-application meeting designated for South San Pedro and District 6 did occur, but the applicant failed to present information and address questions relating to square footage, scope of uses, and general site layout as mandated by the IDO. The occurrence of this meeting without presenting this required information negates this being a valid pre-application meeting and therefore constitutes an incomplete application submittal for their conditional use permit, which is item 3 of our appeal.
So I'm sorry. So you're saying that, and I agree with you, that's the IDO says that general information regarding approximate square footage needs to be in or disclosed at the meeting. Mm-hmm. You're saying it wasn't disclosed at the meeting?
No, it wasn't shared, and we actually brought up specific questions on it. You'll see from the meeting notes on page 0142 of your packet. We did ask, I know I was this participant that asked, we keep hearing the Gateway will be a slice of the Gibson Health Hub. How much space will be allotted for the Gateway Center compared with the rest of the Health Hub? And how much space will be leased out? How much space for the 50 respite beds? To which the applicant answered, the city has contracted with an architect and evaluation has begun. So I don't have an answer on the specific square footage. The analysis is occurring.
Ms. Frame, in the record on page 576 in the facilitator's notes, the facilitator wrote that it was answered. The question was answered that 572 square feet is the approximate size of the facility. Are you saying that? No. Let me finish my question. Let me finish my question. Is it your position? I'm just trying to understand your position again. Is it your position that the IDO requires more than that?
Well, yes. So the 572,000 square feet is the size of the entire facility. Right. That will be the Gibson Health Hub. That's not the size of the Gateway Center. So the Gateway Center is going to be within that facility. And they're saying will be a slice of that, but we don't know how much. They didn't, and that was the question. It's we know there's going to be all these different components that are going to exist within the Gibson Medical Center or the Health Hub. We know that current tenants take up about 25% of that space, but we don't know how much space is going to be going towards the Gateway Center for which they're applying as the overnight shelter.
Okay, so again, my question is it your position that disclosure of 572,000 feet does not meet the IDO requirement for what needs to be disclosed at this meeting?
This is Peter Kalitzis.
Yes.
The full building itself is 572,000 square feet. Part of that usage is under an existing hospital usage.
I understand. I read the record, Mr. Kalitzis. I understand what the minutia is of this Gateway Center. My question is it your position that the disclosure of 572,000 feet does not meet what is required in the IDO for a disclosure at these facilitated meetings?
Yes.
Is that your position?
Yes.
Okay.
Yes.
Thank you. Yes. And I understand the reasoning for that. I just want to know if that is your position.
Sure.
Okay.
No, absolutely. That is our position. And it is our position that the ZHE did not acknowledge or just, make this distinction either in his findings and overlooks this element. Further noncompliance with the IDO is referenced in our appeal item number 8 regarding findings number 26 and 27. The applicant speaks to bed capacity and intake activity with a 500-foot separation from the residential zone during the initial phase. But given the size of the facility and their phased-in approach, in later phases, as the ZHE's decision currently stands, future overnight capacities up to 1,500 would be permitted. An expansion of intake hours would be permitted. An intake with a future separation of 0 feet distance would be permitted, therefore creating an increase in non-residential activity within 300 feet. So the ZHE's decision without conditions placed upon the conditional use permit demonstrates that the decision-making body erred in applying the requirements of the IDO. Now moving on to our appeal items 6 and 7, more substantive issues are exposed. As the applicant,
Ms. Frame, my apologies. I want to go back to can you put the conditional use requirement up? There it is. I'm sorry. The 300 feet. Yes.
Yeah.
So I've dealt with this issue many, many times with liquor appeals under the IDO. The 300 feet requirement, my question is, and I didn't see this in the record, I know that there's a 67-foot distance from that apartment complex, the Pearl or something like that, right?
Mm-hmm.
The one that's directly to the east.
Mm-hmm.
But it's 67 feet to the parking lot for the gateway, correct? Or is it 67 feet from the gateway? I know this area very well because I grew up here. This is where I grew up. And so I didn't see the distance between the actual gateway center structure to the apartment complex, but I could have missed it.
This is Peter Kalitzis. The property line separation is 0. Currently,
I know that, right.
Currently, the distance from the existing property line to the existing building is approximately 500 feet.
Okay.
And based upon the conditional use, the applicant in the future, once they have the conditional use without any limiting conditions, they could do additions to the building, relocations, have people entering at night there, and therefore, without conditions, this would no longer be in effect. And therefore, there would increase non-residential activity within 300 feet between 10 p.m. and 6 a.m.
So you're saying that you want a condition, you think that there should be a condition in the approval if it was approved, that it should be 300 feet. There should not be any non-residential activity within 300 feet of the residential uses, correct?
Correct, as related to the overnight shelter, anything to do with the overnight shelter only we're talking.
So the question is the parking lot, because if you include the parking lot, it's 67 feet. If you exclude the parking lot, it's 500 feet. Okay, I see it.
Okay.
Thank you.
Sure. So we'll go on to our appeal items 6 and 7, where more substantive issues are exposed, as the applicant also failed to adequately address how they will mitigate significant adverse impacts to the community as per IDO 6-6A3C. To this day, the impact study being conducted by the University of New Mexico, which was to inform and guide the applicant's operational plan on mitigating significant adverse impacts to our neighborhoods, has not been completed. Thus far, if research has been done, the applicant has been unable to cite the studies and data which inform their operational plan, and therefore has failed on their commitments to the community and does not adequately address how they will prevent significant adverse impacts. During the zoning hearing,
What impacts do you believe are not being mitigated in the proposal?
Primarily, the two biggest concerns for us, I think they have some really good intentions. We've been discussing with them ways to mitigate these impacts with like a good neighbor agreement, a public safety district, which we'll go into further. However, their operational plan doesn't guarantee that we're going to get these things. It says they intend to have a good neighborhood agreement. They intend to do a public safety district. But also our concerns are in the amount of staffing and personnel that are being allocated for these things. We have where they are going to be doing street outreach. They haven't prioritized our neighborhoods surrounding in terms of street outreach. They say that we will be included in the citywide street outreach, but they haven't prioritized our neighborhoods. We do have some concerns as far as encampments and illegal dumping. In their operations plan, they say that Family and Community Services will refer these issues to the Code Enforcement Division. But the fact is, if it's on private property, all code enforcement is going to do is going to be fine these individuals. It's the property owner's responsibility to clean this up. So we feel that there has been, just some short-sightedness and not adequate allocation for resources and personnel, and also recognizing the city's policy for addressing some of these issues.
Okay, Ms. Frame, let me ask you some questions on the last two issues. You're
Okay.
saying that there's encampments and there's trash that's not being picked up. I assume there's a contribution from the homeless population that's existing in this area now.
Correct.
Is that true?
Well, we certainly have it now. Our concern is when this becomes a hub for the whole city where people will be receiving not just services, but shelter, and it becomes a hub for everything citywide. There will be more traffic and people moving in and out of the gateway, and therefore more potential for this than what we already have.
People.
So your contention about adverse impacts doesn't concern the existing conditions in the area now. You're concerned that this will essentially be a magnet for additional encampments and additional debris being left in the area?
Well,
Peter Kalitz, actually, since the purchase and publication that this is going to be an overnight shelter, there has been an increase in encampments within this area.
But that has nothing to do with this proposal, because this use is not actually online. And so these are existing conditions. So I don't see how the ZHE can control these existing conditions. Certainly there are elements within the city that you contend are not controlling these existing conditions, but that doesn't relate to the proposed use, because the proposed use hasn't even started yet. It's my understanding there aren't even contracts for administration of this use. So I guess my question regarding those two issues, regarding encampments and the existing trash issues, again, that refers to the existing conditions and not what you believe will occur in the future.
No, we see there being an increase in adverse impacts, and our concern is what they've presented in the operations plan. It hasn't been informed by the study that they've promised us would inform and guide this operations plan. They haven't shown us the data as far as what lent into their operations plan, other than things that we've been helping to draft. But the things that we've been helping to draft, they haven't guaranteed to us. They just say, we intend to do this or we intend to do that.
Let's stop for just a second. Oh, there's Mr. Wells. Mr. Wells, we can take a break if you need to walk away for a few minutes.
No, I'm fine, thanks.
Okay, thank you. Go ahead, Ms. Frame.
Oh, no. But that's our concern, is just some of the intention. We don't have this study that's been promised us. It was promised by Carol Pierce to City Councilor Davis when this was first getting underway. It's been promised, at our meetings. Janet Page Reeves, who's from UNM, stated that this was specific to Gateway, that they had been tasked with this by the Homeless Coordinating Council, that it was to be twofold. It's also to look at best practices for serving the unhoused and also for mitigating adverse impacts. And
isn't that part of the Good Neighbor program that's supposed to be continuous, perpetual through the life of the use?
The Good Neighbor program is supposed to be, going throughout the use, but this study has been stated to be like what is supposed to help be guiding their operations plan. And so they knew that the study wouldn't be done until February 2022, which was a full 6 months after the application was submitted.
So you believe that this study is relevant for the ZHE to provide for sufficient mitigation?
Yes, it is our stance that this is what was supposed to address how to mitigate significant adverse impacts.
And how would this study do that? Because I didn't see any information about the details of this study, other than that this study was going to potentially be completed in this month.
Well, I mean, as has been relayed to us, it's saying, I can go to the slide that looks at, what they'll be doing. It's, included a literature review is going to be lived experience review, looking at other, cases and instances of shelters, but it was to build upon the Urban Institute's report, and then navigate concerns and opportunities related to the construction of the Gateway Center shelter. So this is what's been communicated. This is going off of what we've been told, by Family and Community Services. Pat Davis has been told this. We've been told this, that this study is going to help us look at what are the potential adverse impacts, how can we best mitigate them. In this email correspondence between Pat Davis and Carol Pierce, Councilor Davis asks what oversight will be put in place to ensure neighborhood issues and unintended consequences are adequately addressed better than current FACS homeless provider contractors downtown. And Carol Pierce did answer that evaluation will inform the creation of a detailed plan to address community safety concerns.
So again, my question is, do you consider this UNM study to not be part of the Good Neighbor program that is supposed to allow for prevention issues essentially and give the neighborhood a direct line of communication with the Gateway Center?
I see this as separate from the Good Neighbor program because this was supposed to occur initially. I think it could help inform when we're drafting our Good Neighbor agreement, most certainly, because I know in our Good Neighbor agreement that, we've submitted ideas to them. We haven't seen what's being drafted as of yet, but I know we wrote into the Good Neighbor agreement things that we think could help mitigate adverse impacts. But I think this study would give us a lot more information that we just don't have. And I just don't know what data or studies or what they're going off of that's informing their plan. And I mean, my career, those of us on our committee, this isn't our background. This isn't our specialty. We don't know the best ways to address homelessness or how to protect our communities and keep them safe and et cetera. So we're really reliant on other data and studies to help inform us, so that when we're coming to the table and asking about those things or making plans and developing strategies, that it's coming from an informed place.
Okay. It was my impression from reading the record, and my impression sometimes is wrong. It was my impression that the UNM study was to complement some of the issues that were presented, which caused the resolution to be adopted by the City Council, and that it was essentially tied to that it was part of the Good Neighbor program, essentially. But maybe I'm wrong.
I hadn't had that understanding. I understood it because even before we started developing the Good Neighbor program, this study had been discussed between the Homeless Coordinating Council and UNM doing it. They were looking at it, I think, even before the purchase of this property, knowing a Gateway Center would go in somewhere. So this all was determined before we started having input meetings and discussions for a Good Neighbor program. So that was independent of, but would certainly help and assist developing that agreement, is my understanding.
Okay.
And what's been relayed to us.
This is Peter Kalitzis. The terminology that Ms. Reeves used was navigate concerns and opportunities related to the construction of the Gateway Center. So in the development, not just how it operates, but actually how it's set up. An example we might give is whether there are whether they're going to have dormitories with 50 people or rooms with 4 people. We don't know what, for the construction of it, operations will be a part of it, but at the early stage, they have it set up. They've put out contracts. They're working with an architect, and the architect is doing this without the knowledge of what this study is supposed to present, is my opinion.
Okay. I thought that the construction was for the internal buildings, the existing buildings. I didn't know that buildings were going to be raised and reconstructed. Is that your understanding?
The construction is going to be, they're actually going to be reconfiguring the interior, which they will be putting in a permit to the city to tear down walls to reconfigure the building itself.
Okay, so how does that relate to adverse impacts? Let me rephrase that question, because that's a loaded question. How does that relate to the ZHE erroring regarding the adverse impacts and the sufficient mitigation of those impacts?
I can't speak to the interior construction. I mean, our error as far as the ZHE goes that we would like to cite is that when he looks at how they addressed mitigating significant adverse impacts, he just references the operational plan. So we can take you through some of the concerns we have as far as what they've outlined in the operational plan, if that's the only reference point for what they're going to do. And we do have concerns with that, but the other thing is this study was supposed to be a critical component, and our feeling is that they knew this was a critical component. They have communicated that to our city councilor, to the neighborhood representatives, and yet it's missing as far as with their application, and the ZHE just overlooked it. He asked within the hearing. He questioned the applicant as far as the timeline of the UNM study and if it was specific to Gateway. He did ask that in the hearing. But within that, the applicant's representative evaded the timeline question entirely, didn't answer the timeline question, and then did go on to incorrectly state that it wasn't looking specifically at Gateway, that it was kind of looking generally at emergency shelters. And that can be found on the transcript on page 982 of your packet. And this statement is false. It wasn't just kind of looking generally at shelters. It was to help them, inform them with their operations plan for the Gateway Center.
Okay.
So I think it was on his radar during the hearing because he chose to ask them about that, but then in the findings just didn't address it whatsoever. So we already went through the letter and everything from Carol Pierce to Pat Davis, and this that shows you, in the UNM presentation, it shows the objective of the study, what UNM had been tasked with and why. And then, yeah, so that's all in your packet.
Why do you have a problem with the language of intends? And why is that error on behalf of the ZHE?
Sure. Our problem with that, because if you go through the rest of the plan, it says in every other instance, it's saying we will be doing this and this will be implemented and will, everything until you get to the components that deal with security and safety with the neighborhoods. And then all of a sudden, instead of like a definitive will, you have intends.
I understand that, but again, my question is, why is it relevant? Why is it relevant for me to find that the ZHE erred by accepting that?
Well, because our point in our closing argument of the hearing was saying a simple change in wording, the operations plan could handle this. And we also feel that rather than intention, it should be a mandated public safety district. And there should be mandated personnel and resources, and this is one of our other concerns as far as how they're going to mitigate significant adverse impacts, is that within the public safety district, they aren't speaking to adding personnel and resources. They say they will better coordinate existing resources and personnel. And that just concerns us because we know even with the adverse impacts we experience now, that there are not adequate personnel to respond to the calls and to address the issues and the burden that is placed on property owners. And so in our minds, they should be adding things to this versus just better coordinating, what's there, because what's there is not able to adequately address them. And then we do see the potential for more adverse impacts moving in, just because we're going to have more people. I mean, there are going to be more people moving in and out of this area.
I guess and maybe I'm beating a dead horse, but I guess my question is, I understand you don't like this language, but how does it violate the IDO or the resolution to include this kind of language? And bottom line is, why should the ZHE find that it should be obligatory that these things be there instead of intends?
Well,
without extracting what you wish to have.
Sure.
Why did the ZHE err? And how did the ZHE err in acknowledging this?
Well, I think he's, by it not being required of them and not being a condition that's attached, because again, the IDO doesn't mandate that they have a good neighbor agreement. The IDO doesn't mandate that they do any of these things. And that's where we are concerned and want those conditions be attached. So that, because it's not mandated by any other law. So we're just asking, please attach these conditions to the permit, that they are mandated to have a public safety district, that we do have a legally binding good neighbor agreement, because that's another thing we've been asking for throughout this process, because without it being legally binding, from what we've seen with other good neighborhood agreements within the city, like Wells Park, which they themselves cite as an example of a good neighbor agreement, they're not really worth the paper they're written on. I mean, there's no accountability in there if they're not legally binding. And we'll go further in our presentation. I mean, we'd really like something more akin to a community benefits agreement, like we were seeing with the proposed United Stadium and Borellis. It was brought to our attention in January through our Homeless Services System Committee that there had been a Homeless Coordinating Council framework document drafted back in October of 2020, which I wasn't privy to. I know new members on the committee were not privy to, but it outlines a whole bunch of different economic relief and economic development towards the area that wasn't included in the operations plan at all. And we think that would also help. So these are just things, they're not required. We understand that, but that's why we're asking for them to be conditions of the approval.
I mean, just to be frank with you, I don't think I can help you with that. Those are political issues, and my jurisdiction is very limited. But let's move on.
I gotcha. Okay. So
Mr. Chavez, when you get to a breaking point, can we take a break, please?
Sure. Who is this, Mr. Sanchez, or is this Mr. Moya?
It's the reporter.
You need a break. Oh, no worries. Your hands are getting tired. How about let's take a 5-minute break, Mr. Sanchez?
That's fine.
Okay, let's come back at 10 minutes after 10.
Sounds good. Thank you.
Thank you, folks.
Peter, can you spell your last name for me, please?
K-A-L-I, T as in Tom, S as in Sam, I, S as in Sam?
Kalitzis.
Yes, sir.
Thank you.
Okay. Mr. Sanchez, can we go back on the record?
I'm ready, sir.
Okay, let's go back on the record. Oh, Mr. Moya, are we back on the record over there?
Yes, sir, Mr. Chavez.
Thank you so much. Okay, let's proceed. Ms. Freeman, we've already been here over an hour with your arguments. Can we move on a little quicker?
Sure.
I just want to make sure that I don't want to hear political arguments. I really want to focus on your case as to how the ZHE erred, because that's the limit of my jurisdiction.
I got you.
Okay.
So yeah, so
Mr. Hearing Examiner, this is Leslie Padilla.
Ms.
I do
Padilla?
think this is relevant because all of these points go to the ZHE's a lack of attention to the evidence that the neighborhood association submitted about their concerns about potential adverse impact. So I actually do think this is all relevant to showing that the ZHE did not adequately look at the evidence in the record, and he unduly favored the evidence of the city. So I actually do think this is all relevant to errors that the ZHE made.
Okay, Ms. Padilla, I disagree. I don't think there's evidence that the ZHE did not read the record. You would have to show me objective evidence, and that's practically impossible. He's presumed to have read the record. I know the ZHE, and I know that he is a very competent attorney, and I'm sure he read the entire record, as did I. I didn't see a lack of attention. I think he paid attention. The issue that I am to look at is how the ZHE erred. So it's best if you folks can focus on showing me how the ZHE erred. I mean, if you want to make political arguments and waste your time, that's fine. But I cannot pay attention to political arguments because that is not not only my expertise, but that is not what I have been delegated to do. I have been delegated to determine how the ZHE erred. And so if you can help me, I can help you, but you have to focus your issues on the ZHE errors. So please, look, I don't want to argue the point with you. I recognize that you disagree with me, and it's okay. And I disagree with you, but let's focus on the issues. Thank you.
okay. So as far as mitigating the adverse impacts, he referenced their operations plan. Where we see the shortcomings in that, first off, if we look at the first item under security and safety in the surrounding Gateway Center in their operations plan, they cite first and foremost APD having a strong presence in Southeast Albuquerque. And this is misleading because the Southeast is an area already overburdened and undermanned in terms of police and public safety. Even as recently as January 25th at a District 6 coalition meeting, Commander Langwit, who is the APD representative there, stated that with a limited number of officers, they are concerned with how they are going to staff the proposed public safety district at the Gibson corridor. I mean, we do have a shortage of patrol officers on the streets, and this is the implications of this in the most populated district of the city, whose command center has the highest record of overall crime, is evidenced in these reports. And I don't have to, these are in your packet. I don't have to spend a lot of time here. What we're trying to show is that even as things stand now, they are overburdened, undermanned. And this lack of personnel and resources is another concern for us. You know, they keep showing as a beacon for us that the Albuquerque Community Safety Department, ACS, will be, you know, there and available to provide street outreach. But like I had said before, our communities haven't been prioritized with the street outreach for that. And despite our request for this measure, and staffing and personnel for this department is unknown at this time. If they do have that allotted, they haven't addressed it in the operations plan or to us. Currently, the personnel within the FACS department to address calls regarding the unhoused is limited to 7 people citywide. When asked at an Albuquerque Indivisible meeting, how many people would be adequate for the job for this, given the size of our city and the unhoused population, Carol Pierce did guess that it would be between 20 to 30 people. So, you know, effectively we're working with like less than half of what would be adequate here. So this is a concern. Like if we're just to look at the operations plan for mitigating significant adverse impacts, we do have a severe shortage of personnel in all these different departments. Furthermore, with the city's policy for addressing encampments, in the city council meeting December 20th, Councilor Bassan asked a question during the city council meeting where she related constituents' issues trying to get the city to clear an encampment outside their business, in which it was communicated to her that clearing any illegal dumping or encampments on private property is the responsibility of the property owner. So this goes back to the point I was talking about earlier, that in their operations plan, they say, oh, FACS will refer this to code enforcement, and that's how we'll take care of it. But the fact is, code enforcement, all they're going to do is fine the property owner. It's ultimately the policy is the burden of the property owner. So we just don't see these as effective solutions. And, you know, despite what, you know, Mr. Wells wrote in his letter saying that we're asking for guarantees against any negative or unpleasant conditions and that we're asking for the impossible, all we're asking for is a realistic plan of mitigation. And we just don't think the operations plan does that. And the only guarantees we're asking for are the conditions that we're asking to be put on the permit, as far as a legally binding good neighborhood agreement and a mandated public safety district and bed capacity. Those are the guarantees we're asking for, not that we're asking for any guarantee against any potential adverse impact. So I want to make that point very clear. And I'll just skip through some of this evidence because this is in your packet. These were some of the things we did provide as evidence that the ZHE decided was not relevant, because he was saying the adverse impacts that we're speaking to reference, temporary shelters, even though these news articles right here, these are all referencing, problems that business owners, neighbors face at Coronado Park and the areas surrounding pickup and drop-off locations, shuttle stops that have been there, will be there, that go to service providers and shelters. Steelbridge, they in their own report here speak to the adverse impacts. This is a report done by a provider. They are not a temporary provider, they are a permanent shelter and provider. So I don't feel like that finding was accurate. We do want to speak though in terms of equity and equality with our district, that we do shoulder a huge burden within our district of providers of services to the unhoused. We do, out of the city's 83 providers of these services, we have 43 of them in our district. So that meaning District 6 does carry more than 50% of the city's burden in addressing homelessness out of 9 districts.
But so isn't that because there's quite a homeless problem in the Southeast area?
Well, you can see a number of homeless throughout the city. And the city actually tells us this quite often, that you have, a lot of homeless throughout the city. We certainly see a lot of them with the shelters downtown, but this is a problem we're all dealing with citywide. I don't want to relate it to one particular district. I think it's more visible here though, because of all the services that we have. And so we do shoulder a significant portion, a majority portion of this burden. And so that's when we'd like to get into the ZHE's findings 16, 17, and 18 regarding equity. The question of equity, we understand, is a key city planning principle. And he did chastise us for not understanding the difference between equity and equality. But in doing so, he missed the entire point that it is not equitable to open a potentially large-scale shelter in a neighborhood that's already doing far more than its fair share to alleviate homelessness. When the ZHE tried to explain that the city meets the comprehensive plan's requirements for equity, he noted that people in different parts of Albuquerque have different starting places, which we understand. And understanding the starting point is important in assessing whether a city's action is equitable. But the reason you have to know the starting point is to assess whether the city's actions will do more for the people who are at a lower starting point so that the inequities are eliminated over time. And by exacerbating the potential for homelessness and adverse impacts in District 6, we feel that this is not doing more, that it's making the inequities worse. The equity calculation here is about the imposition of adverse impacts. It's whether, as the comprehensive plan requires, social responsibilities are borne fairly across the Albuquerque area. District 6 already is an example of tremendous inequity in our city. When there are 9 city council districts, the fact that a single district already accommodates so many services is clearly not equitable. The ZHE also justifies the city's plan on equity grounds by claiming that people might need and want different things. And the fact is, as representatives of the appealing neighborhoods, we can tell you that we want the same things as residents of all the other districts. We want safe neighborhoods, walkable sidewalks, good schools, clean parks, et cetera. And to this end, the city has much work to do in providing for the neighborhoods surrounding Gateway. By opening the Gateway Center in District 6 with so many uncertainties, without a mandated good neighbor agreement, and without concrete plans about how other districts will do their fair share, District 6 will be at a further disadvantage in obtaining those things we all want. We'd like to look at the area that will be housing Gateway, the International District. This area's strongest asset is the people of the community, being the most racially and ethnically diverse area of our city. However, these neighborhoods also experience the greatest poverty. Now this screen grab here, I'm sorry, it's low res, but the red and orange areas represent the highest percentiles of low income populations. So that you'll see that excluding commercial and industrial census tracts, the highest percentile of low income and assisted housing are within these neighborhoods whose populations are also ranked as the lowest income of the city. So the city is concentrating services for the unhoused in an area already plagued by crime and suffering the detrimental effects of poverty, and in essence is putting disadvantaged and vulnerable populations in a severely disadvantaged area. And the impacts of these actions could most boldly be equated with the consequences of historic redlining in minority neighborhoods, and at the very least, do not honor the vision for sustainable neighborhoods within the city's comprehensive plan, which the ZHE did not address, which brings us to item 4 of our appeal, stating that his finding number 15 did not follow the IDO requirement that the requested conditional use be consistent with the ABC comprehensive plan. When you look at the guiding principles of the comprehensive plan, it outlines strong neighborhoods should have diverse housing and amenities. But with an oversaturation of service providers to the unhoused, with Gateway being another, and the lowest income population having the highest percentile of low income housing, with more being proposed as an extension of Gateway, this project ignores principle number 1. We also must recognize the presence of unhoused people outside one's place of business impacts the success of local businesses and the economic vitality of a community, which is principle number 3. And despite these strategies that I referenced earlier that we just became aware of in January, that the Homeless Coordinating Council had developed as far as incentives and economic relief, all these things to help business owners and economic development strategy, these weren't included in the operational plan for the adjoining neighborhoods.
Did you say the operational plan?
Yeah, or
Okay.
yeah, either of the documents. The other one's called the administrative policies, I want to say. But yeah, so these weren't included and they'd clearly been developed, but they're just not part of it. And this is where we would like to see some of these things. If we have a legally mandated, like a community benefits agreement, these strategies they were developing would be great as far as helping them meet the guiding principles for sustainable neighborhoods and economic vitality within the comprehensive plan.
Can't these issues still be addressed in the Good Neighbor program?
They haven't come up, and our concern is, so our last meeting that we had with the city where they went through, it was a COA operations plan meeting was in August. We have not had any contact from the city. There's been no discussion of a Good Neighbor program since then. So, and this, we had 2 input sessions, the pre-submittal meeting on the committee that I'm serving on, the homeless services system meeting. None of these meetings were any of these things addressed. So that just gives me cause for concern. I wouldn't have even known about this if it wasn't another neighborhood representative that emailed this to all of us on the committee now, homeless services system, that this had been developed. So this was never part of the equation. This was never something that got brought up. And I think it would have been good to have included in the operations plan. And I would like to have that be part. I think I speak on behalf of all of our neighborhoods. They would like to have this be a component of the conditions, that there be a community benefits agreement, because that is a legally binding good neighbor agreement, essentially.
So you're saying that the legally binding agreement should occur before a conditional use should have been approved?
No, we're not saying that. We're asking that that be a condition
I see.
for approval. Yeah, that be attached to it.
Okay.
For guiding principle number 5, community health, all residents are protected from harm where they live, work, learn, and play. Everyone has access to healthy food, parks, and open space, and a wide range of amenities and services. Despite recent renovations at the neighborhood parks like Wilson Park, et cetera, the encampments and hazardous refuse left by the unhoused residents at these parks and the surrounds does not make them safe. And the operations plan allocation of existing resources and personnel to address these issues are just not adequate. So the applicant argues that the city is addressing the ABC comprehensive plan by addressing policies impacting the unhoused. And as far as addressing homelessness, we agree with this. Where they fail, though, is in their disregard for the policies and guiding principles for the community at large. And our argument is that you cannot tip the balance in favor of one portion of the population, in this case, the unhoused, and threaten the sustainability of the rest of the community. And by ignoring these policies for the community at large for sustainability and the guiding principles of the comprehensive plan, the ZHE has acted arbitrarily and capriciously. So it's with that aim of sustainability that we're proposing the conditions be attached for their permit for approval. First, given the state, I'm gonna have to find myself. Given the state's 86% shortage of behavioral health providers and the city's track record in transitioning people into affordable housing, it is a market that is shrinking, and the oversaturation of services in this area, and not to mention the shelters that they themselves have cited as success models that they would like to emulate. We feel that sheltering in excess of 150 people is not human scaled and does not hold the promise of moving people out of the shelter system into housing. And with what they have outlined now, they are looking at sheltering upwards of over 250 people, and in essence are biting off more than they can chew. So
Ms. Frame, let me ask you this question.
Sure.
How do you believe that I have authority to deal with these issues? Because I'm at a loss here. Are you saying that the ZHE erred by not including, by not actually fiddling with the minutia of the use, that is limiting the number of people that can come into this facility, limiting square footage, limiting employees, limiting parking, limiting all those things? Are you saying that ZHE should have done those things?
Yeah, we think it would be responsible and make it for sustainable to have a condition attached that puts.
Where in the IDO does it require that the ZHE deal with these issues regarding the use? Are you saying generally that the ZHE did not consider these when he determined that there is sufficient mitigation?
Yes, we're saying he did not address this and come through it. And we understand, again, that it's not part of the IDO. That's why we're asking for there to be a condition as part of the permit approval. Okay. Peter has something to add here.
Okay.
Most of this comes down to, a lot of it is, we requested when we put in early on Parkland Hills, a limit, a defined limit on the number of overnight shelter residents. That was not addressed at all, because if there were, we had suggested 90 residents for the first 2 years to see how well they could implement everything else, and then come back in 2 years to up the number when they've demonstrated that they're capable of mitigating significant adverse impact. By not including any conditions at all, there are 0 conditions. The example of this facility, which is the second largest city-owned building that we have, could potentially have 1,500 residents, whatever the fire marshal will allow. So in effect, by not putting conditions on, the decision makes it okay to, says it's okay that 1,500 people is okay. It will not create significant adverse impact. It's okay. That's okay.
I understand your argument. Thank you. Okay.
So those were the conditions. It started with bed capacity limits, but the others are what we've already talked about, which is mandating the public safety district. That would also then, within the operations plan, provide an operating budget that specifies for and provides for added personnel and resources so that they can do, the necessary measures for preventing significant adverse impacts.
Ms. Frame, are you almost finished?
Yes, this is it.
Good, because I want to give Mr. Wells
of course
equal time.
Yeah. So we just, and with the language in the operations plan that is loose and irresolute, we would just ask that it becomes, more concrete and does include a detailed operating budget, just for the purposes of accountability and sustainability. And so as the applicant claims to have the best of intentions where these items are concerned, they should not object to them being guaranteed items of their conditional use permit approval. And then, our most recent discovery, the fact that the very, naming of this or the permit being asked for being for an overnight shelter with proposed stays of up to 90 days, that doesn't meet the definition within the IDO at all, as the IDO says it would be 24 hours or less. So we do feel that it would be more applicable to have a permit for like a large group, a large group home versus because the overnight shelter, even what they're asking, it does not meet that point of the IDO. So that's everything we have. Everything's in the packet, obviously, for any further review. But that would be our close. Thank you.
Okay, thank you so much. Mr. Wells, you have the opportunity to cross-examine Ms. Frame, Mr. Kalitsis, or Ms. Padilla. Ms. Padilla did not testify for very long, but you have the opportunity to cross-examine these folks.
Thank you. We don't care to cross-examine them.
Okay, thank you. Proceed, sir.
Thank you. My name is Larry Wells. I'm representing the City of Albuquerque Department of Family and Community Services on these applications. I would like to say at the outset of my comments that Family and Community Services is committed to working with the neighbors. Throughout this process, not only the individuals who've spoken this morning, who've been very well spoken, but many parties who've given input in this process have given thoughtful comments that are being taken into account by Family and Community Services. It's the position of the department that they're listening and they're working on adapting as the very best that we can do for this project. I'd like to say that we disagree about sorting out what's going on in these applications and in this hearing. In our view, the question before the hearing officer is whether or not the decision of the zoning hearing examiner will stand. And that limits us to particular areas that have to do with the conditional use permit. The breadth of concerns of the community that Family and Community Services intends to address goes far, far broader than what is before the land use hearing officer today. So the fact that I'm going to make comments about why we think the decision of the examiner should be sustained, that it was appropriate, does not mean that we disagree with many of the concerns that have been raised and that they won't be the subject of much further discussion. I know Director Pierce is concerned to convey this message to the neighbors. We feel that the conversation, the back and forth that has occurred in the many meetings that have happened, and in this very process is part of listening, part of discussing. We're not going to agree about everything, but I just want you to understand that the matters that I'm going to disagree with you on today have to do with whether or not these issues in the context of this appeal are should prevail or not. It doesn't mean we don't think that the comments of the neighbors should be listened to on these comments. There's much, much more to happen. As the hearing examiner commented, many of these aspects are political matters to be addressed with the council on an ongoing basis. Many of these matters are administrative issues that the department is in the process of addressing. So I just want that to be my comment at the outset, and I'm going to give a presentation about the items that we think should be considered by the hearing officer today. I think we've covered the fact that what kind of project this is, that we're seeking a conditional use approval to allow an overnight shelter, that is a conditional use in the MXH zone. We had the two hearings before the zoning hearing examiner, and really the primary reason that it was continued to the October hearing was so that the city could finalize the operations plan and the administrative procedures. And those are in the record in their final condition. The fact that those documents have been finalized doesn't mean they won't be adapted and amended in the future. It's the first step of giving something sound and finished that can be used as a basis for the future. The responsibility of the zoning hearing examiner was to review the applicant's justification for the request and approve it if it found that the justification is sound based upon substantial evidence. It doesn't require the examiner to be perfect. I know that there's a feeling among some of the neighbors that the zoning hearing examiner may have ignored them. As someone who comes before administrative bodies on a regular basis, I'm sympathetic with the feeling that the decision maker didn't agree with an argument made. It happens to all of us. That doesn't mean that the zoning hearing examiner ignored something. It means he made a decision. And I don't think the record reflects that the zoning hearing examiner ignored the points that were made by the neighbors. At any rate, the decision before the hearing examiner is to decide, not make a new decision on all of this record, but to look at what the zoning hearing examiner did. And the question is, did he make one of the following mistakes? Did he act fraudulently, arbitrarily, or capriciously? And as the hearing examiner knows, those are high standards. I mean, that's a high bar. The fact that there might be evidence in the record that would support a contrary conclusion, in other words, that the ZHE could have decided differently, that's not the question. The question is, was it fraudulent, arbitrary, or capricious, meaning without substantial evidence, essentially? And then that takes us to the second standard is, was it supported by substantial evidence? Meaning, is there evidence in the record to support the decision that was made? And the final item is, did the ZHE err in applying the IDO requirements or a plan, policy, or regulation? It is a whole record review, meaning that the hearing officer will look at the entire record to decide if one of these mistakes was made. And the hearing officer is required to view the evidence in the light most favorable to the decision. And that's because the hearing officer is not making a new decision on the evidence. He's judging the zoning hearing officer. As I mentioned in my letter, I think the appeal can be reduced to three major issues. And that is R-21-141, were those requirements satisfied? The IDO procedures, were they adhered to? And the conditional use criteria, were they adhered to? We believe that they were, but I'm going to go through these in some detail to underscore why the department feels that these were satisfied. At the outset, I'd like to comment that it's common in these appeals before the land use hearing officer for the parties to refer to the comprehensive plan goals and policies. It's a fundamental part of deciding whether requirements have been met. I would point out that it's uncommon for us to be here where the project itself is specifically driven by comprehensive plan goals and policies. What I mean to say is we're not here for an apartment project or an office building or a fast food drive-through that, while is permitted under goals and policies, is not the central focus of any goal and policy. It's a different kind of case. It was before the ZHE, and it is here. And that is, there are specific goals and policies that call for this implementation. That doesn't mean it doesn't have to pass muster in the total picture of what we're here to look at today. But it means that it's quite different in that this is specifically in the goals and policies. Goal 9.4 to make homelessness rare, short-term, and non-recurring. Goal 9.5 to expand the capacity to provide quality housing and services to vulnerable populations and to ensure maintained safe transitional housing. The fact is that the city is here to do something that our comprehensive plan calls for it to do. And it's a concrete step forward to try to solve, or at least make a big advance on the homelessness problem. I recognize that the neighbors understand this and they're not in disagreement with these goals and policies. I just point out that when the zoning hearing officer was balancing the evidence, balancing compliance with goals and policies and what was addressed, the very purpose of this particular project that's being looked at today was among the goals and policies, and that carried some weight. So I'd like to talk about Resolution R-21-141 first. The record reflects that the department did hold the two community input sessions within the 45-day period called for. One was on June 10th. One was on June 12th. Input from these meetings was posted on the city's website. The Good Neighbor Agreement that's called for in this is a work in progress. It's underway. We're listening to comments right now about what ought to be included in it, and that's a process that is ongoing. I know there was criticism about whether or not proper notice was given. And first of all, I'd like to point out that the resolution itself, the hearing officer commented that it perhaps wasn't crafted as best it could be, but resolutions are different than things like the IDO, which are detailed laws as they're crafted. The resolution doesn't say anything about notice, and we're not trying to be insincere here. We know that notice and communication is an important thing, but from a technical point of view, there are not notice requirements in the resolution to be adhered to. There was a great deal of communication going on in the community about this project, and I would like to point out some of these details so that the full context of community outreach is understood, because there weren't specific notice requirements. As far as community input meetings, there were meetings in April, as early as April 19th, community meeting at the medical center. And then in April 27th, the Parkland Hills neighborhood meeting. April 28th, a Trumbull neighborhood meeting. June 3rd, Elder Homestead neighborhood meeting. June 7th, District 6 community and provider meeting. All of these occurred before the June 10 and June 12 Resolution R-21-141 community input sessions. And there were 3 more meetings following that, but there was communication happening in the form of meetings. The city took it upon itself to produce YouTube videos to try to inform on this subject. The first of those was way back in December of 2020. There were 2 of them in December. There were 3 of them in February, and there was 1 in March of 2021. So there were 6 video presentations. And then we talk about email notice or who's getting notice through email. There were MailChimp newsletters that went out beginning in November of 2020. There were 2 of them then. There were 2 in December. There were 2 in January. There were 2 in February. And there were also MailChimp newsletters in March and April. All 10 of these went out before the June meetings in compliance with R-21-141 that occurred on June 10th and 12th. And there were a total of 9,000 of those emails were open because they have a record of that. So
what was the subject of all this notice to the general populace? Was it regarding an offer to participate in the process, or?
No, these weren't specific meeting notices. These weren't even notices. They were newsletters, they were YouTubes, because there's no specific notice requirement in R-21-141. I think we have to look at the context of what kind of outreach, what kind of communication was going on. That's the reason I'm discussing these. I'm not saying that any particular newsletter was a formal notice of a meeting. Clearly, back before the resolution was passed, none of them could have addressed specific notice. I'm saying that the discussion of this topic and to keep the community informed was an ongoing matter that it had been going on for many months. I say it because I think the context of the outreach and the efforts at communication is important to understand, since there weren't specific notice requirements.
So what was the specific subject of these, I won't call them notices, of these outreach endeavors?
Well, they all dealt with homelessness. I don't have the exact contents of the newsletters that went out, except that I know that they dealt with that issue. Some of the YouTube videos were broadly topic. The first one that I have here, December 2nd of 2020, was, will the proposed Gateway Center be one large 300-bed facility? The second one was, will the West Side project close when the Gateway Center opens? Then there were ones on causes of homelessness, winter weather, and conversations on the webinar.
So this was general information regarding the issues pertaining to the Gateway Center.
And some of them went beyond the Gateway Center. I don't say that these were formal notices. The picture I'm trying to paint is that this was not a void that the department was operating in. The department was constantly trying to inform and trying to address these topics. And so we feel that the community was engaged. I understand that some members of the neighborhood feel that proper notice wasn't given. Well, that's an opinion, which we respect, but I don't believe that's an indication that the zoning hearing officer made an error in deciding that the requirements of R-21-141 were complied with. I'd like to talk about the IDO procedures. There may not be an issue if I'm interpreting some of the comments made today about the notices that were required under the IDO for the pre-submittal neighborhood meeting going out, but just to review the record, the city's consultant sent the June 4th email notification for that specific meeting to the District 6 Coalition, the South San Pedro Neighborhood Association, Elder Homestead Neighborhood Association, Parkland Hills, Trumbull Village, and Siesta Hills Neighborhood Association. There is something in the record I'd like to address that was an error on my part, and it was pointed out by one of the appellants, and that is, of the 4 neighborhood associations that initially were stated to have been informed as a courtesy, only 3 of them end up being a courtesy. It is correct that Parkland Hills was legally entitled to the notice it did receive, and it wasn't a courtesy. There is no, with respect, there is no legal significance to this because the notice was given. And whether one gives a notice as a courtesy or one gives it as a legal requirement is really not relevant. but I would like to apologize for my error in my letter to the hearing officer, where I threw all four of those neighborhood associations together. The reason is that there was a confusion about the address of the project. It was first just the address for the larger building, and later on, when the address for the smaller building was pointed out, that made Parkland Hills directly adjacent.
Thank you.
I'd like to review the conditional use decision criteria. Pardon me. I'll go through each of those 6 items to explain what the department's position is on these. Consistency with the comprehensive plan. The current zoning of the property, MXH, expressly allows an overnight shelter as a primary conditional use. We believe that the city's application and the evidence in the record demonstrates that this use is consistent with the comprehensive plan. I've already talked about the homelessness goals and policies. The appellants contend that the applications did not adhere to policy 9.4.3, and I think it's the feeling that of equitable distribution of resources. It's true that there are many resources for homelessness in Council District 6. The city has pointed out that locating the facility at the Gibson Health Hub furthers policy 9.4 for a number of reasons that are in the record, but probably some of the most important is that the location is accessible to trusted nearby service providers, not only on the facility itself, but in the International District, and it's within the San Mateo Major Transit Corridor area. The zoning hearing examiner discussed the equity issue, and I believe he's correct when he says that the comprehensive plan does not require distribution of resources and so-called unwanted land uses equally throughout the city, but it rather institutes a policy that resources and these types of uses should be located equitably in consideration of the totality of the circumstances. This is where I think the department simply disagrees with the neighbors, and we agree with the zoning hearing examiner, and that is that we were able to demonstrate that locating the shelter carefully and equitably in an area of need surrounded by social and governmental assets, that desirable outcome would be achieved by this. I think we've shown that the city demonstrated that its operations will benefit not only people suffering from homelessness, but others in the immediate area and the community as a whole. And that we've submitted policies and regulation and enforcement plans that will be implemented to minimize negative impacts.
It seems to me that in the comprehensive plan, there's a general goal regarding equity, and it's not to distribute equally unless it can be shown that there's an equal distribution of the social problems. It seems to me it speaks to an economy of scale for these uses based on what is necessary, where it's necessary, without regard to equally distributing these assets or resources. I think that the ZHE specifically quoted from section 4.2 in the comprehensive plan. So there's very clear language as to the intent and the definition of that term in the comprehensive plan. So I agree with you there.
I do think the examiner had that right. I think the record reflects that. The second criteria is compliance with the IDO, the Development Process Manual, and other adopted city regulations. Pardon me. Other than R-21-141, there are no provisions in the Development Process Manual or other city regulations applicable to overnight shelters, and no conditions specifically applied to the development of this property that would bear upon this. The only use-specific standard for an overnight shelter is the requirement in IDO section 4-3C7 that it shall be located at a minimum of 1,500 feet in any direction from any other overnight shelter. And the record on appeal makes it clear that that is complied with. The next shelter is over 2,000 feet away. The third criteria is no significant adverse impacts on adjacent properties, the surrounding neighborhood, or the larger community. We respect the fact that this is the primary concern of the neighbors. The city believes, and we think the record reflects, that providing secure shelter and services for individuals living in vulnerable situations, the Gateway Center will be a positive impact on the adjacent properties, the surrounding neighborhoods, and the larger community that are currently dealing with an unhoused population. This is not simply an overnight shelter. It's a comprehensive facility designed to treat underlying individual issues that cause homelessness and to provide solutions and a transition to better living. In short, it's not a quick fix. It's much more. I think most of us recognize that homelessness is not just a problem of not having a home. There are complex reasons about how people got there, and it takes complex services and analysis to help people get out of it. That's what the city is prepared to do. The record reflects the great depth of analysis that has been given by the Department of Family and Community Services to do the very best we can as a city to solve this problem. We feel that the operations plan and the administrative policies address many of the community's concern, including mitigation of potential impacts. We know that there's going to be more discussion about this, and we fully expect that there will be modifications and changes made. It's going to be an ongoing project. It is a first step, maybe the most important step, to truly comprehensively trying to deal with the homelessness problem in the city of Albuquerque. And the Department of Family and Community Services is dedicated to getting it right. And we know that means listening to the neighbors. The operations plan addresses many things. I'm not going to go through all the details, but there's discussion about the transportation, how we're going to get people there, how we take them away, the operating hours, security of the entrance, the physical design. There was a little discussion about this, I believe, earlier, and that is the physical, these are all interior improvements except for lighting and other security things. And we're not rebuilding or building a new building. There are going to be upgraded lighting and so forth, but there is a design concept called design and crime prevention through environmental design principles.
I'm familiar with those concepts. I've dealt with them in appeals. I mean, those are the cutting edge design principles that are hot around the country right now. So
that's what we think too. And it's true, these haven't been taken from principles and design to construction plans as of yet. It's correct what one of the neighbor speakers said that, well, this hasn't happened yet. Well, it's true. We're at, just for context, people who deal with real estate like I do know this, but we're at the stage of getting the conditional use permit. And then many, many other things follow that. And that's the normal way things happen. In other words, you have to have the land use approval, and then you start doing the things to make the project work. What's different about these applications, in my opinion, is there's far more detail. I've never seen so much detail in what a developer brings before the particular land use board for approval. The department has gone out of its way, because we know about the community concern, to put as much on the table at an early point. But this project is at a very early point. It hasn't started yet. So these are things that will happen. Construction plans will be drawn in accordance with the design principles that go into the drawings that the architect makes. All of that is to follow. The operations plan covers security, weapons policy, how entry and exit will work, how they'll deal with reaching capacity, critical incidents response, trash removal, pedestrian safety, how that's going to be addressed, encampments, and the good neighbor agreement, which, as I said before, is a work in progress. So we believe that the zoning hearing officer had all these factors before him to deal with community impacts and made a decision that is sustainable, that is supported by substantial evidence on the record. I'll turn to the next criteria, which sounds a lot like, this is subsection D, sounds a little like subsection C, no material adverse impacts on other land in the surrounding area without sufficient mitigation or civic or environmental benefits that outweigh the suspected impacts. I've always interpreted this particular subsection to be physical rather than other kinds of impacts. In other words, what the physical impact of what's on the land will be. This is more of what I just discussed, that it's going to be interior construction, interior renovation. There won't be any increase in noise or vibrations and won't create any adverse impacts in this manner. So I don't believe D comes into play at all. Subsection E, there was some discussion about this in the presentation by the appellants. That is no increase in non-residential activity within 300 feet of a lot in a residential zone district between the hours of 8 p.m. and 6 a.m., pardon me. First of all, the record reflects that the intake activity will be more than 500 feet from the closest residential zone, and it's buffered by a parking lot. My opinion is that to really understand this subsection, you have to look at what the word no increase means. What an increase compared to what? Well, it certainly doesn't mean, is it an increase compared to the vacancy in the building right now? I think the only way to look at this that makes sense is, would the type of use granted by the conditional, by this permit, increase the non-residential activity that is permitted under the permitted uses in the MXH zone. And I think clearly it wouldn't do that. That's because there are many permitted uses under MXH. Maybe the most obvious is to look back at the last active use, or one of the last active uses in this building, and that is running a hospital. You know, running a hospital has activity that occurs between 8 p.m. and 6 a.m. if there are any emergency arrivals. And so I think that subsection E is clearly satisfied.
You think it's satisfied by the nature of the proximity, though, more importantly, correct?
Yes.
Okay.
Yeah. It's more than 500 feet away. And that's what the record reflects. F is no negative impact on pedestrian or transit connectivity. I believe those are addressed in the record with the shuttle service to and from designated on-site pickup and drop-off locations, prioritization of improvements on sidewalks and pedestrian crossings after evaluating them over on Gibson, possible modification of transit routes if that appears to be beneficial after evaluation. And the city intends to conduct a speed study on Gibson Boulevard, looking into that as well. So I believe that F is satisfied as well. I'd like to go back to a few of the comments that were made in the appellant's presentation and give our response to some of those. The neighbors were of the opinion that the zoning hearing officer flipped the burden of proof. I don't believe the record reflects that. I acknowledge that the zoning hearing officer was listening and sometimes critical and asking some questions. I don't think that because he didn't make a decision in favor of the appellants, it means he ignored or overlooked evidence or flipped the burden. I think I've already discussed the discussion on R-21-141 about the failure to invite businesses. We think that there was a lot of discussion in the within the community about this project. There's not a specific notice requirement in R-21-141. There was lots of participation at the meetings. And as I said, the resolution is not precise about any kind of notice requirements. I'd like to address the UNM study that was mentioned. There's a lot going on with this project that does not have to do specifically with these applications for a conditional use permit. The UNM study has been mentioned and discussed, I think, with city councilors and in other contexts as well. And I'm sure it could have been discussed in some of these meetings that have occurred. But it's not a part of any requirement under R-21-141. It's not a part of any requirement under the IDO. There's no indication in the record that the zoning hearing officer based his decision in part on the existence of an ongoing UNM study. In short, it's something else that's happening. It's part of the big picture of what the Department of Family and Community Services is doing to make this a success. But the fact that it wasn't completed before this conditional use permit was heard or at any other point in this process is not meaningful. There are many things, as I said, that the department is doing that don't specifically have to do with whether a conditional use permit should be granted. More specifically today, whether the zoning hearing examiner made a sound decision. Our view is that the Gibson Health Hub is an ideal location for the Gateway Center because of its size, location, the ease of access, its relative separation from existing residential development, and its relative proximity of complementary services. That's a really important point, the synergy of services that we think will make this a success if the applications are granted. The Good Neighbor Agreement is going to be developed to ensure that the city is aware of and mitigates issues that may arise in a prompt manner. We think the record in this case clearly demonstrates that the zoning hearing examiner carefully considers the city's request. He carefully considered the opposition to the applications. There's much material in the record. And we believe he correctly decided that the policies under R-21-141 were complied with, and the IDO and the comprehensive plan all call for the approval of this project. And so we would urge the hearing officer to conclude, as we have, that the zoning hearing examiner's decision is supported by substantial evidence and it justifies the granting of the conditional use permit. I conclude my comments, Mr. Hearing Officer.
Thank you, Mr. Wells. Just for the record, Ms. Frame, Mr. Kalitzis, and Ms. Padilla, Mr. Wells is not subject to cross-examination because he's an attorney licensed to practice law. You cannot cross-examine an attorney. You do have some time for rebuttal. I will give you some time for that, but I want to first offer the City Planning Department staff a bit of time to respond to any of these issues. Under the rules, the planning staff have that opportunity. Is there anybody here from planning staff? Ms. Patton Quintana, you are here. Is there anything that you would like to add for the record? If so, I need to swear you in.
Yes, I'm here. Thank you, Mr. Chavez. I do not have anything to add. Thank you for the opportunity.
Okay, thank you so much. Okay, so now we have time for your rebuttal. The appellants can make a rebuttal, closing argument, and we can end it there.
Mr. Hearing Officer, this is Leslie Padilla. I have one point, and then Ms. Frame may have some additional minor points to wrap up. I did want to point to the issue that Ms. Frame mentioned earlier, and that is the issue with the definition in the IDO of overnight shelter. I know we've discussed this as an overnight shelter, but as Mr. Wells in his own comments just now made clear, it is not an overnight shelter. This is intended to provide longer term housing for unhoused people. There's the record is replete with evidence that the city does not intend this to just be simply an overnight shelter or a daytime gathering facility. People are allowed to stay up to 90 days. There are services provided 24 hours a day. Drop-offs are accommodated 24 hours a day. So I will point out that the definition of overnight shelter in the IDO is that it is a facility that provides sleeping accommodations for 6 or more persons for a period of less than 24 hours. So I think that's something that's been overlooked here, and it probably deserves your attention. Thank you.
So what is your position that this should be called? I mean, if it doesn't meet a definition in the IDO, then normally what happens is that we try and pigeonhole it into a definition that closely resembles or is similar to that definition. Go ahead.
Yes, Mr. Hearing Officer, it would most likely qualify as a large group home, which is also a conditional use permit. So the conditional use is still going to be required even under that approach, but I think it's a pretty significant legal issue that the city's application as an overnight shelter, it just does not qualify as an overnight shelter. And I know you have had some recent cases where also proposed uses did not meet the IDO's definitions of those uses.
Okay, thank you.
Mr. Chavez, when we get to another point, can we take a break, please? This is a reporter.
Let's take a break now because I would like a break myself. And I'm going to allow you more time. And then I'm going to allow Mr. Wells to respond to that specific issue because I agree with you. It's a significant issue. Okay, let's take a 5-minute break and we will go back on the record at 11:16. Thank you. Okay, my apologies. My dogs had to deal with some issues with my dogs. I'm home, so okay. Let's go back on the record. Mr. Sanchez, are you ready to go back on the record?
I'm ready, sir.
Okay, Mr. Moya, are we on the record as well?
Yes, sir, Mr. Chavez.
Okay, good. Okay, go right ahead, Ms. Padilla.
Mr. Hearing Officer, no, that was the point that I wanted to make and make sure the hearing officer was aware of that legal issue. I think Ms. Frame has some additional closing points.
Okay, thank you, Ms. Padilla.
The main point I have is just, when we go back to R-21-141, while it has been pointed out that notice was not a requirement as far as the language to the businesses, we do feel that that was the implication. That's how we understood it based off our conversations with the city and what had been relayed to us as far as what they were going to be doing, ensuring that we're going to be sending out flyers for this, et cetera, that they understood it as their responsibility. And with Will's discussion of the 9,000 MailChimp newsletters and the YouTube videos and everything, it does demonstrate that they understand the need for outreach and for notification on issues surrounding these developments. But all of these newsletters and YouTube things that he did cite all were disseminated before the purchase of this property even occurred. So none of that was relating to the property we're discussing at this hearing. So I do know the city is on top of their communication with us as far as, I'm a panelist on one of their meetings, with the neighborhood associations, but I do think this was something that was overlooked on their part, and it shows they understand, how critical this kind of communication is. It's not as much a rebuttal. I guess it's a question. Are there time for questions later?
Questions for who?
For either like you to go through, to the other party. I guess I'll just address it because I didn't hear more of it after we spoke. As far as the IDO requirement that they're supposed to present to us at the pre-submittal meeting, all this information that never was really addressed as far as general scope of uses, approximate square footage, like all of that material, design guidelines, et cetera, that we didn't receive that information in that meeting. So I don't know if someone could speak more to that as far as that our confusion about the IDO, or how do we address that, I guess?
Well, it is in the record. I have the facilitated meeting notes from the facilitator, and I believe there are emails that describe some of those things, but I will essentially rely on the facilitation meeting notes to see if that requirement was met. Mr. Wells argued, I believe, generally that it was. Maybe I will ask him to maybe detail that a little bit more. So anything else? Ms. Frame?
No, we do not. Sorry, I was on mute.
It's okay. Mr. Wells, would you like to address those two issues, the overnight shelter issue? And before you do that, I'd like to point out that I do not have the application, the specific application submitted with, let me back up. With the application, I do not have the form that's submitted with the application, the form to the planning department that describes generally what the application is. That's not in the record. So Ms. Fishman, if you could supplement the record with that within the next 5 days, I'd appreciate it. And when you do that, send a copy to the appellants as well and to Ms. Crystal Ortega so that she can include it in the city council's record. Can you do that, Ms. Fishman?
Yes, I can. Thank you.
Thank you. Okay. And Mr. Wells, would you care to address those issues?
Sure. The first one was whether this really qualifies as an overnight shelter. First, I'll tell you that when the application went before for discussion with the zoning officer, that's what he thought it was, and that's what he told the Department of Family and Community Services to apply under. I think I know why. And when I look at the definition of group home, and then I look at the definition of overnight shelters, we all know that overnight shelters are not required to and do not enforce a one-night only requirement. It's very common that they are serving people for more than one night. Why the definition uses that exact language, I can't tell you. I can tell you that in my opinion, this may fall between two definitions in the IDO. But I think it's, just partly a language issue. I do believe this qualifies as an overnight shelter as that term has been interpreted in the city of Albuquerque with some consistency over time. I will also raise the technical issue for the benefit of the hearing officer and the record. This issue was not raised below. It could not be addressed by the other parties. It's being raised for the first time on appeal. And for that reason, we believe that it does not qualify as a reason to determine that the zoning hearing officer was in error. The zoning hearing officer never had an opportunity to hear this contention from the appellants, and therefore we believe it was waived. As far as the second issue, which is the contents of the pre-submittal meeting, I think that we have to look at this in the context of these applications as they generally come before in the administrative process. And that is that size, square footage, and all of these matters are commonly addressed with buildings that are going to be built, or how's this use going to happen? How will it occur? I think it's been interpreted by the appellants to mean exact details about the particular operation. My view is that in looking at the full context of discussions that were had and reading the minutes of that meeting, that everybody knew what they were talking about. And I would say that it's not perfect, perhaps, if you don't have exact square footages discussed and so forth. Certainly, we knew we were talking about a 572,000 square foot building that is the subject of the conditional use permit, the whole building. And the fact that less than that is going to be used does not mean that we didn't know what the conditional use permit was going to be addressing. I would simply say that I believe the record shows that there was substantial compliance with that section of the IDO.
Thank you so much. Great. So let's do this. Let's go off the record. I will have a recommendation for the city council. I'll send an email to all the parties simultaneously, as well as to the city council and their staff. And I guess everybody who was on that mailing list for this Zoom hearing will receive it as well, because that's how I send it out. I just attach it to and forward it. And we'll have that within 15 days, which is the time allotted to me under law. Okay, thank you so much, folks. Enjoy your day. Thank you for the hearing. It was a nice, long hearing, and I learned a lot. Bye-bye.
Thank you to everyone. Bye-bye.